Sir, I stopped you for the damaged taillight. I also need clarification about your relationship with the minors in the vehicle.
They're family friends. I'm driving them home, that's all.
One of them said you're not his father. They're scared, sitting in silence while you're ordering them to stay quiet.
You playing with fire, deputy. You don't understand.
At 11:47 p.m. on a dark stretch of Highway 9 outside Crestfield, Georgia, a 29-year-old patrol deputy named Vanessa Cordero activated her lights behind a black Lincoln Continental drifting between lanes with a broken taillight. She expected nothing. A routine stop on a quiet overnight shift covering for a colleague on leave. The kind of call that usually ended with a warning and a wave. It didn't. The driver lowered his window slowly, already holding his license between two fingers, like a man who had done this before and never had to explain himself. He was well-dressed, calm, controlled. He identified himself before she could finish her opening line. Judge Clarence Devereaux, presiding judge of the 14th District Family Court. His voice carried authority, even on the shoulder of a county road at midnight. He told her the taillight had been an ongoing issue, that he was heading home from a family function and that she could let this one go. Cordero noted the tone. Not a request, an instruction. She kept her flashlight steady and moved it past the driver's seat toward the back of the vehicle. 4 children sat in the back, ages roughly 6 to 11. None of them moved. None of them spoke. Their eyes stayed low, fixed on their laps or the seat in front of them. One of them, a small girl in the rear passenger seat, was trembling visibly. Her hands were pressed flat between her knees. Cordero's training told her to note the detail and continue the stop. She did. She asked for registration. Devereaux handed it over without a word, his eyes watching her in the side mirror. She stepped back toward her cruiser, Bodycam recording, flashlight beam cutting across the dark interior of the Lincoln one more time. That was when a boy sitting behind the driver's seat turned his head slowly and looked directly into the lens mounted on her chest. His lips barely moved. That's not my dad. Judge Clarence Devereaux was 58 years old and had spent 22 of those years on the bench of the 14th District Family Court in Crestfield, Georgia. He was not just a judge in that town, he was an institution. His name appeared on the donor walls of 3 local nonprofits. He gave the keynote address at the county's annual Foster Care Appreciation Dinner every year for over a decade. He had been profiled twice by the Crestfield Herald as a pillar of justice and compassion, a man who had dedicated his career to protecting the most vulnerable children in the system. He ran a mentorship program for youth aging out of foster care, personally selecting participants and meeting with them regularly in his chambers. Local attorneys spoke about him with a mix of respect and caution. His courtroom was strict, his rulings were final, and his influence over custody placements, foster assignments, and juvenile case outcomes was nearly absolute. But beneath the accolades and the authority, there were things people noticed and never said aloud. Court clerks who saw certain children brought to his chambers outside of scheduled hearings. Social workers who were told specific children needed to be placed in homes Devereaux personally recommended. A bailiff who once saw a child leave the judge's office in tears and was told it was a difficult custody conversation. None of it was ever reported. None of it was ever questioned. The attorneys who practiced before him needed his favor. The social workers depended on his rulings. The community trusted his image. And Devereaux had spent 2 decades making sure that image never cracked. Until a deputy on a quiet highway asked the wrong question at the right time, and a boy in the back seat answered it. Officer Vanessa Cordero had never been the type to back down from authority. She was the daughter of a Guatemalan mechanic and a Dominican home health aide, who raised 3 children in a 2-bedroom apartment in Macon. She joined the Harmon County Sheriff's Office at 24, not because she came from a law enforcement family, but because of her cousin Sophia. Sophia had been placed in foster care at age 9 and bounced through 4 homes in 2 years. She came back different, quiet in a way that wasn't shyness. Cordero never got the full story. She didn't need to. She understood that the system had failed someone she loved, and she decided she would never be the person who looked the other way when something felt wrong. In 5 years on the job, she had built a reputation that made some colleagues uncomfortable. She once cited a county commissioner for DUI on a back road outside Harmon and refused to void the ticket when his chief of staff called the station. She filed a formal report on a fellow deputy who had roughed up a teenager during a traffic stop, even after being told it would make her unpopular. Her sergeant once described her in a performance review as someone who doesn't care about your title, just your behavior. It was meant as a compliment. Not everyone took it that way. That night, she was working a solo overnight shift on Highway 9. 12 hours, mostly silence, mostly empty road. She had pulled over 2 vehicles before the Lincoln. Both were routine. Both ended in under 5 minutes. When she saw the Continental drifting across the center line with a busted taillight, she expected the same. A warning, a signature, a good night. What she got instead was a man who told her who he was before she asked. 4 children who sat like statues, and a whisper from the back seat that made every nerve in her body fire at once. She didn't drive away from it. She called it in. Cordero walked back to the Lincoln and positioned herself at the rear passenger window. Her flashlight moved across the back seat slowly. The 4 children hadn't shifted since she first approached. The 2 boys sat behind the driver and front passenger seats. The older girl, roughly 11, sat in the middle. The younger girl, the one who had been trembling, was pressed against the far door. Cordero leaned slightly and spoke in a voice low enough that Devereaux would have had to strain to hear. "Hey, you kids doing okay back there?" No one answered. The older girl's eyes flicked toward the driver's seat and then back down. The younger girl's hands were still pressed between her knees. The boy who had whispered moments earlier stared straight ahead now, jaw tight, as if he regretted what he had said. Devereaux's voice came from the front. "Officer, they're tired. It's late. I'm transporting them home from a family gathering. They're foster children in my care." Cordero didn't look at him. She kept her eyes on the children. "Do you have paperwork for them? Foster documentation, custody orders, anything with their names?" Devereaux paused for half a second. "Not on me. It's at my home. I'm a family court judge, officer. I don't carry case files in my vehicle." Cordero straightened. She noted the details her training told her to catalog. No seatbelts properly fastened on 3 of the 4 children. The younger girl was not wearing shoes. No booster seat for the smallest child. No documentation of any kind for 4 minors in a vehicle with an unrelated adult approaching midnight. She keyed her radio. "Dispatch, this is Unit 17. I need a second unit to my location on Highway 9, mile marker 41. I have a welfare concern involving 4 minors." Devereaux's tone changed. "That's not necessary. I've told you who I am. You can verify it with 1 phone call." Cordero met his eyes through the window. "Sir, I'm going to ask you to stay in the vehicle. I've requested backup. We'll sort this out when they arrive." Devereaux stared at her for a long moment. Then he said something the Bodycam captured with perfect clarity. "You have no idea what you're doing, Deputy. You're going to regret this." Devereaux didn't wait for backup. He pulled out his phone, scrolled with the casual ease of a man who had powerful people on speed dial, and pressed call. Cordero watched from behind the vehicle, Bodycam recording. Her microphone picked up fragments. His tone shifted from calm to firm. The words "Patrol Deputy," "Highway 9," and "handled immediately" came through clearly. Within 2 minutes, her radio crackled. Sergeant Ray Loomis, her shift supervisor. "Vanessa, what's your status on Highway 9? She responded, "Welfare concern, 4 minors, no documentation. 1 child made a statement. I've requested backup." A pause. Then Loomis's voice dropped lower. "Listen, the driver is Judge Devereaux. He's known to the department. He sits on the County Public Safety Board. You might want to extend professional courtesy and let him get those kids home." Cordero stared at the Lincoln's rear window. She could see the outline of the older girl's head, motionless. She keyed the radio. "Sergeant, a child told me the driver is not his father. I have 4 minors with no documentation, no proper restraints, approaching midnight. I'm not releasing this vehicle until backup confirms the welfare of these children." Silence. Then Loomis came back. "Copy. Backup en route." Inside the Lincoln, Devereaux adjusted his rearview mirror. The body cam caught the reflection. He was watching the children. The older girl had her hand on the younger one's knee. The boy who had whispered sat rigid, staring straight ahead. Devereaux's expression was composed, but something had shifted behind his eyes. The confidence was still there, but alongside it sat something sharper. He turned slightly toward the back seat and spoke. The microphone picked up only part of it, but digital enhancement during the investigation would later recover the full sentence. Remember what I told you, not a word. Deputy Terrence Kamal arrived 11 minutes later. He stepped out slowly and walked toward Cordero with the expression of someone who already knew this was complicated. She briefed him in a low voice. Broken taillight, erratic driving, 4 children, no documentation, no shoes on the youngest, a child's whisper, and a driver who identified himself as a sitting judge before she'd asked his name. Kamal listened with his arms crossed. I know who he is, Vanessa. He's been at department dinners. The sheriff shakes his hand at the courthouse Christmas reception. Cordero didn't blink. Then you understand why this has to be done right. Kamal looked at the Lincoln, at the dark shapes in the back seat, at the man behind the wheel. What do you want to do? She told him. Ask Devereaux to step out. Request documentation. If he couldn't produce any, they were calling Child Protective Services and a forensic child advocacy officer. Kamal exhaled. You know what happens if we're wrong. Cordero's response was immediate. You know what happens if we're right and we drive away. He nodded once. They walked to the Lincoln together. Cordero tapped the window. Judge Devereaux, I'm asking you to step out of the vehicle. He opened the door slowly, straightening his jacket as he stood. His posture was controlled, expression flat. This is a mistake, he said. A serious mistake. Cordero replied without hesitation. Sir, do you have any legal documentation authorizing you to transport these children? His silence lasted 3 full seconds. The body cam counted them. I don't have to explain myself to a patrol deputy. I am a judge of the family court. Those children are under my supervision through a mentorship program I personally administer. Cordero asked one more time. Paperwork? Names? Case numbers? He had nothing. Cordero called Child Protective Services at 12:23 a.m. A forensic child advocacy officer named Imani Sutton arrived at the Harmon County Fire Station 40 minutes later. The children were transported separately from Devereaux and brought inside one at a time. Sutton was trained for this. Soft voice, open posture, no uniforms in the room. She started with the boy who had spoken on the highway. His name was Terrell. He was 8 years old. He had been in the foster system since age 4. He told Sutton he was taken from his group home 3 days earlier by a woman he didn't know who said he was going to a special family visit. He said the man in the car told him to call him Sir. He said they stayed in a house with no other adults. He said he didn't want to go back. Sutton moved to the oldest girl, 11 years old. Her name was Kiara. She didn't speak at first. She sat with her arms wrapped around herself, eyes on the floor. When Sutton asked if she had been to the man's house before, Kiara nodded slowly. How many times? Kiara held up 4 fingers. Sutton asked what happened there. Kiara used language that triggered mandatory reporting protocols immediately. A 6-year-old boy in the 3rd interview barely spoke at all. He flinched when a male firefighter walked past the open door. The 4th child, a 7-year-old girl named Amara, didn't answer questions directly. Sutton gave her crayons and paper. She drew a picture of a room with no windows and a large bed. She drew a tall figure standing next to it. Sutton stepped out of the room, closed the door behind her, and called the district attorney's office. Her voice was steady, but her hands were not. We need a warrant tonight. A judge from the neighboring district was woken at 2:41 a.m. to sign the warrant. No one in Crestfield's court system could be involved. By 4:15 a.m., a team of investigators from the Harmon County Sheriff's Office and the Georgia Bureau of Investigation entered Devereaux's residence, a well-kept colonial on a tree-lined street in the town's wealthiest neighborhood. The front rooms looked normal. Family photos on the mantel, legal texts on the shelves, awards and framed newspaper clippings on the study wall. The basement told a different story. Behind a locked interior door, investigators found a furnished room with bedding for multiple children, small clothing folded in stacks, personal items belonging to minors, electronic devices concealed in a floor safe, and a ledger-style notebook with entries spanning years, each referencing children by initials, dates, and coded notations that investigators would later decipher with the help of child exploitation analysts. Digital forensics was called in before sunrise. The scope of the investigation expanded within hours. Devereaux was arrested at the scene. He was still wearing the suit from the traffic stop. He said nothing when they put him in handcuffs. His attorney arrived within the hour, demanded to know the charges, and was handed a warrant that ran 4 pages. Outside, the first light of morning broke across Crestfield. Neighbors watched from behind curtains as a man they had admired for 2 decades was guided into the back of a federal vehicle. None of them spoke. None of them yet understood what had been happening inside that house. But the children did. And now, finally, someone had listened. The investigation into how Devereaux operated moved fast once investigators understood what they were looking at. He hadn't acted on impulse. He had built a system. As presiding judge of the 14th District Family Court, Devereaux had direct authority over custody placements, foster assignments, and juvenile case outcomes. For over a decade, he had used that power to position himself as the final word on where vulnerable children ended up. He cultivated relationships with specific social workers who processed his recommendations without question. He maintained ties to 2 group home administrators who flagged children with no stable family connections, the ones least likely to be missed or believed. His mentorship program, celebrated publicly as a model of judicial compassion, served as the pipeline. Children selected for the program were brought to his chambers for meetings that no one supervised. Some were assigned to foster homes connected to people he controlled. Court records later showed that Devereaux had personally intervened in the placement of at least 19 children over 7 years, overriding caseworker recommendations in 12 of those instances. Each time, the reassignment moved the child closer to his reach. The social workers who facilitated it fell into 2 categories. Some were manipulated, pressured by the authority of a judge they couldn't afford to cross. Others knew. They looked the other way because Devereaux controlled their caseloads, their courtroom outcomes, and in some cases, their careers. One social worker would later testify that she had raised the concern once and was told by her supervisor to drop it. The supervisor's explanation was brief. "He's a judge. You're not." That was the end of it. When news of Devereaux's arrest reached the Crestfield legal community, the silence was immediate and telling. Attorneys who had practiced before him for years offered no comment. 2 social workers connected to his cases were placed on administrative leave within 48 hours. The director of the county's child welfare office submitted a resignation letter with no public explanation. A local journalist named Franklin Cobb, who had twice profiled Devereaux as a community hero, began receiving anonymous tips within days. Former court staff, foster parents, a retired bailiff who said he once saw a child leave the judge's chambers crying and was told not to ask about it. Cobb published his first investigative piece within 2 weeks. It detailed 3 formal complaints filed against Devereaux over the previous decade with the state's Judicial Conduct Board. All 3 had been dismissed after what the board described as preliminary review. One of the complainants was a foster mother named Gloria Vance. She had reported concerns about a child's behavior after visits connected to the mentorship program. She described nightmares, withdrawal, language that alarmed her. She was told she was being alarmist. 6 months later, her foster license was revoked on a paperwork technicality. She lost custody of 2 children she had been raising for 3 years. Vance told Cobb she had always believed the revocation was retaliation. Now, reading the charges against Devereaux, she was certain. The system didn't fail those children by accident, she said. It failed them because it protected him. When the article ran, the Judicial Conduct Board issued a statement announcing an internal review. By then, the FBI was already in Crestfield. The FBI and Department of Justice opened a joint federal investigation 9 days after the traffic stop. What began as a single incident on Highway 9 had expanded into something the U.S. Attorney's Office described internally as systemic and predatory. Federal agents seized Devereaux's electronic devices, court records, personal correspondence, and financial statements. Digital forensics uncovered encrypted files and communications with individuals in 2 neighboring states. Financial records showed a pattern of payments to the group home administrators who had funneled children into placements Devereaux controlled. The money was structured in small amounts, routed through a nonprofit Devereaux had established under the umbrella of his mentorship program. On paper, the funds were labeled as youth enrichment grants. In practice, they were payments for access. Federal prosecutors convened a grand jury within 3 weeks. The indictment, when it came, was 34 counts: trafficking, exploitation, conspiracy, obstruction of justice, wire fraud connected to the nonprofit, civil rights violations under color of law. 2 social workers and 1 group home administrator were named as co-conspirators. Devereaux was denied bail. His attorney, a high-profile defense lawyer from Atlanta, called it a rush to judgment driven by media pressure. The U.S. attorney held a brief press conference outside the federal courthouse. She stood behind a podium with no notes and spoke directly into the cameras. This office has investigated many cases involving abuse of power. This is among the most disturbing. A sitting judge used the institution designed to protect children as a tool to exploit them. We will pursue accountability at every level. Devereaux watched the press conference from a federal holding facility on a wall-mounted television. According to a corrections officer who was present, he showed no reaction. He sat with his hands folded, expression blank, staring at the screen as if watching someone else's life collapse. The federal trial began 4 months later and lasted 5 weeks. The courtroom was full every day. Prosecutors opened with the Bodycam footage from Highway 9. The jury watched in silence as the Lincoln Continental rolled to a stop on the dark shoulder. They heard Cordero's voice, calm and professional. They saw the children's faces illuminated briefly by her flashlight. And they heard the boys whisper, "That's not my dad." Several jurors looked down. One pressed a hand to her mouth. The prosecution then built its case methodically. Forensic evidence from the residents, testimony from child psychologists who had evaluated the victims, digital evidence extracted from encrypted files, financial records mapping payments to co-conspirators, and the testimony of the children themselves, delivered via closed-circuit video so they would not have to face the man who had hurt them. 8 victims were identified in total, spanning 7 years. Each child had entered Devereaux's orbit through the family court system he controlled. Each had been selected for his mentorship program. Each had been placed in homes or facilities connected to people who answered to him. The defense attempted every available angle. They argued the children's testimony had been riven. The judge ruled the broken taillight and erratic driving provided clear, probable cause. They argued the children's testimony had been coached. Prosecution experts dismantled the claim, with forensic interview recordings showing open-ended, non-leading questioning. They claimed the digital evidence was circumstantial. Federal analysts walked the jury through file structures, timestamps, and encryption methods that proved deliberate concealment. A cooperating social worker took the stand and described in detail how Devereaux selected children and how she was too afraid of his power to refuse. Her voice broke once. She did not ask for sympathy. The jury gave her none. The jury deliberated for 1 day, guilty on all 34 counts. The courtroom was still when the verdict was read. No gasps, no outbursts, just silence and the sound of the court clerk's voice moving through each count, one after another, the word guilty repeating like a hammer on stone. Devereaux sat motionless, hands flat on the table, eyes forward. His attorney closed his folder and said nothing. Sentencing came 6 weeks later. A senior federal judge was brought in from out of state to preside. Before the sentence was delivered, 3 of the older victims submitted impact statements. One was read aloud by a prosecutor because the victim could not speak without breaking down. The statement described years of abuse by someone the system told them to trust. Someone who wore a robe and sat above everyone else in the room. Someone who decided where children went and who they belonged to. The sentencing judge addressed Devereaux directly. You were entrusted with the most sacred responsibility the legal system can offer: the protection of children who had no one else to speak for them. You weaponized that trust. You used the institution designed to shield the most vulnerable members of this society as your personal instrument of predation. There is no sentence this court can impose that fully accounts for what you have taken from these children. Devereaux was sentenced to 67 years in federal prison with no possibility of parole. He showed no visible emotion. At 58 years old, the sentence was effectively life. He was led from the courtroom in shackles, past the families of victims, past the journalists, past the cameras. He did not look at anyone. The door closed behind him. His robe, his title, his reputation, his freedom. All of it gone. The fallout reshaped Crestfield from the inside out. The State Judicial Conduct Board was restructured after an independent audit revealed systemic failures in handling complaints against sitting judges. 3 board members resigned. New legislation was introduced requiring independent oversight of all family court placements and mandatory cross-referencing of judicial involvement in foster care assignments. The county's child welfare department was placed under state supervision for a minimum of 5 years. Internal emails uncovered during the federal investigation showed that supervisors within the department had been aware of irregularities in Devereaux's placement recommendations, but chose not to act. One email sent from a senior case manager to the department director read simply, "He's the judge. We don't question the judge." That email was cited in the governor's public statement calling for wholesale reform. The 2 cooperating social workers received reduced sentences. One was given 3 years. The other received probation and mandatory testimony in related proceedings. The group home administrator who had facilitated access to children was sentenced to 12 years. Gloria Vance, the foster mother whose license had been revoked after she raised concerns, was publicly reinstated. The state issued a formal apology. She regained custody of the 2 children she had lost and was invited to serve on the newly formed Civilian Oversight Panel for Child Welfare. Officer Vanessa Cordero was recognized by the State Attorney General's office for her actions during the traffic stop. She declined all media interviews. A single quote appeared in an internal department memo distributed to every sheriff's office in the state. "I just did what the training says. If something doesn't feel right, you don't drive away from it." The Bodycam footage from Highway 9 was viewed over 4 million times in the weeks following the trial. Legal analysts, child advocacy organizations, and law enforcement training programs dissected it frame by frame. But the moment everyone returned to was the same. A dark highway, a flashlight beam sweeping across the back seat of a Lincoln Continental, 4 children sitting in silence, and a boy who turned his head, looked into the camera mounted on a deputy's chest, and whispered 5 words that broke the case open. "That's not my dad." Without that whisper, Devereaux might still be on the bench. Without Cordero's refusal to defer to a powerful man's title, the children might still be in his reach. Without the body cam preserving the truth in a format that could not be denied, rewritten, or buried, the system that protected him might never have been forced to answer for what it allowed. The children are in protective care. They are receiving long-term psychological support. The boy who spoke has not been publicly identified, and will not be. He is reported to be doing well. His name will not appear in this story because he has already done the bravest thing anyone could ask of him. He spoke when silence was safer, and someone listened. This case was brutal, but the case on the right spirals completely out of control.
Don't sit there acting confused. You expect me to believe this is your vehicle?
It is registered to me. You verified that.
Registered doesn't mean earned. Cars like this don't just land in the hands of someone like you without something shady behind it.
Am I being charged with a crime?
No.
At 9:47 on a quiet Sunday morning along Meridian Boulevard in Crestwood, a matte black Lamborghini Urus rolled through a green light at the intersection of Walnut and 5th. The driver signaled, changed lanes, and continued at exactly the posted speed limit. 6 car lengths behind her, Officer Brent Hargrove, 42, a 16-year veteran of the Crestwood Police Department, sat behind the wheel of his patrol cruiser and watched. His dash cam was running, his body camera was active. Both would later confirm what happened next. Hargrove followed the Lamborghini for 6 full blocks. He didn't activate his lights. He didn't run the plates. He just followed, watching, waiting for something he could use. At the 7th block, he hit the sirens. He called it in as a suspicious vehicle, possible stolen, and noted a failure to signal during a lane change. The dash cam would later show the signal blinking clearly, 3 full seconds before the merge. The driver, who pulled over without hesitation, placed both hands on the steering wheel and waited calmly for the officer to approach, was Federal Judge Geneviève Okafor-Laurent. She was 53 years old, a sitting judge on the United States Court of Appeals for the Fourth Circuit, and one of the most respected jurists in the federal system. She was on her way home from visiting her elderly mother across town. She wore a linen blouse, sunglasses pushed up on her head, and no identification that would mark her as anything other than what Hargrove had already decided she was: a black woman driving a car he didn't believe she could own. Officer Brent Hargrove had been with the Crestwood Police Department since he was 26 years old. In that time, he had accumulated 31 civilian complaints, the overwhelming majority filed by Black and Latino residents. The complaints described a pattern that never changed: pretextual stops, aggressive questioning, searches conducted without consent or probable cause, property seized and never returned. Hargrove had earned a nickname in the neighborhoods he patrolled most heavily. Residents called him the Collector. Not because he collected evidence, but because he collected belongings. Cash pulled from wallets during traffic stops, jewelry removed during pat-downs and logged as potential proceeds of criminal activity, electronics confiscated under civil asset forfeiture statutes that allowed police to take property without ever filing charges. Over the past 5 years alone, Hargrove had seized more than $340,000 in cash and personal property from citizens. Almost none of those seizures led to arrests. Almost none of that property was ever returned. 2 prior cases involving allegations of planted evidence had been quietly settled by the city before reaching trial. Internal Affairs had reviewed his file multiple times and closed every investigation without action. His supervisors described him in evaluations as assertive and proactive. The police union representative, a man Hargrove met for drinks twice a month, had personally intervened to block 3 separate disciplinary recommendations. Younger officers who questioned his methods were told to mind their own calls. Those who pushed further were transferred. Hargrove operated with the confidence of a man who had never once been held accountable. And on this Sunday morning, with his lights flashing behind a Lamborghini Urus on Meridian Boulevard, he had no reason to believe that was about to change. Judge Geneviève Okafor-Laurent was not the kind of person who announced herself. She never had been. Her father, Chukwemeka Okafor, came to the United States from Lagos in 1974 with $200 and a work visa. He drove a taxi in Washington, D.C. for 31 years, 6 days a week, often pulling double shifts so his children wouldn't carry the debt he did. Her mother, Ruth Ann Laurent, grew up in Orangeburg, South Carolina, the granddaughter of sharecroppers. She cleaned office buildings at night and took community college classes during the day until her body gave out before her ambition did. Geneviève was the youngest of 3. She earned a full scholarship to Howard University, graduated summa cum laude, and was accepted to Yale Law School, where she was one of 9 black women in her class. She clerked for a Supreme Court justice. She spent a decade as a federal prosecutor in the Civil Rights Division of the Department of Justice, trying cases involving police brutality, unlawful search and seizure, and systemic discrimination in law enforcement agencies across the Southeast. 9 years ago, she was appointed to the United States Court of Appeals for the Fourth Circuit. She had since authored or joined rulings in more than a dozen landmark cases involving police misconduct, qualified immunity, and constitutional violations under the 4th and 14th Amendments. Legal scholars described her opinions as surgically precise. Defense attorneys feared her bench. Civil rights lawyers cited her rulings like scripture. None of that was visible on Meridian Boulevard that morning. What Hargrove saw when he looked through that window was a black woman in a linen blouse sitting behind the wheel of a car he had already decided wasn't hers. And that was all he needed. Hargrove approached the driver's side with his right hand resting on his belt. His body camera captured the angle from his chest. The dash cam recorded the wider frame from the cruiser. Both were rolling. Both would preserve every word of what came next. He didn't greet her, didn't introduce himself. His first words were a demand. "Whose car is this?" Judge Okafor Laurent looked up at him, hands still on the wheel. "It's mine. You have proof of that?" She reached toward the center console slowly, movements deliberate and visible. "My license and registration are right here." Hargrove took the documents and studied them far longer than necessary, flipping the registration back and forth, holding the license up as though comparing the photo to a face he had already decided didn't match the vehicle. He walked back to his cruiser. He ran the plates. The vehicle came back registered to Genevieve Okafor Laurent. The license was valid. No warrants, no flags, nothing. He sat in the cruiser for nearly 4 minutes. Then he got out and walked back to her window. The body camera captured what came next without interruption. "Step out of the vehicle." "For what reason?" Okafor Laurent's voice was steady. "I need you to step out." "I've provided my documents. Everything is in order. Why am I being asked to exit my car?" Hargrove leaned closer. "I'm detecting the odor of marijuana coming from inside this vehicle." There was no marijuana in the car. There had never been marijuana in the car. Forensic analysis would later confirm that no trace of any controlled substance existed anywhere in or on the vehicle. But in that moment, on the side of Meridian Boulevard, with no witnesses yet watching and both cameras running, Hargrove had just manufactured the one claim he believed would give him the authority to go further. And he intended to. "Step out, now!" Judge Okafor Laurent opened the door slowly. She placed one foot on the pavement, then the other. She stood upright, hands visible at her sides, and spoke clearly enough for every microphone in range to capture it. "I am complying with your order under protest. I do not consent to any search of my person or my vehicle." Hargrove didn't acknowledge a single word. He took her by the arm and moved her to the rear quarter panel of the Lamborghini, positioning her against the car with both palms flat on the matte black paint. He patted her down with hands that moved too slowly and pressed too hard, running his palms along her sides, her waist, her pockets. She stood motionless, jaw tight, eyes fixed on the street ahead. A second patrol unit had already arrived. Officer Nolan Fitch, 29, 5 years on the force, stepped out and approached. Hargrove jerked his head toward the open driver's door. "Toss it." Fitch hesitated. His eyes moved from the woman standing composed against a $250,000 vehicle to the registration document sitting clean on the hood. He opened his mouth like he was going to ask something, then didn't. He reached into the car. They emptied her purse across the hood. Wallet, reading glasses, a leather planner, a tube of hand cream, receipts. They opened the glove compartment and pulled out the owner's manual and insurance papers. They lifted the floor mats. They searched the center console, the door pockets, the trunk. In the back seat, they found a small zippered bag containing her mother's prescription medications. Hargrove unzipped it, spread the bottles across the leather seat, read the labels one by one, then left them scattered where they fell. They found nothing illegal, because there was nothing illegal to find. Across the street, in a second-floor window of a brick colonial, a woman named Celeste Gerard had been watching since the lights first flashed. Her phone was recording. She didn't say a word. She didn't need to. Hargrove stood in the middle of the road, feet apart, hands on his hips, staring at the open doors of a vehicle that had given him nothing. No drugs, no weapons, no contraband. No justification for a single thing he had done in the last 20 minutes. The body camera on his chest kept recording. He turned back toward Judge Okafor Laurent, still standing where he had placed her, palms flat against the side of the car, and what came out of his mouth next would be replayed in federal court in news broadcasts, in training seminars, and in living rooms across the country. Let me ask you something. A woman like you, driving something like this, how does that happen? She said nothing. He stepped closer. Did your boyfriend buy this for you? Some rapper? Some dealer? Because I've been doing this a long time, and cars like this don't end up with people like you unless something dirty is going on. His voice was casual, almost conversational, as if he were stating something so obvious it barely needed saying. This car costs more than you'd make in 10 years, so I'm going to ask you again, where did the money come from? Okafor Laurent turned her head slightly. Am I free to leave? Hargrove's expression hardened. You'll leave when I decide you can leave, not before. Angle. A second neighbor, 2 houses down. Angle. A second neighbor, 2 houses down, had stepped onto his porch and started filming. A passing driver slowed at the intersection, window down, phone raised. 3 cameras were now recording from 3 directions, and the body camera on Hargrove's chest made 4. None of them would miss a word of what had already been said, and Hargrove, standing in the middle of Meridian Boulevard, with his chest out and his badge catching the morning sun, had no idea that every syllable was building the federal case that would end him. There was a moment, captured clearly on the body camera, where Judge Okafor Laurent's eyes moved from Hargrove's face to the badge on his chest and then back again. It lasted less than 2 seconds, but lawyers who reviewed the footage later would describe it as the moment she made her decision. She could have ended it right there. 1 sentence. I'm a federal judge on the 4th Circuit Court of Appeals. The stop would have collapsed on itself. Hargrove would have stammered. Fitch would have frozen. Apologies would have tumbled out, fast and hollow and desperate. She knew that. She also knew exactly what that would mean. It would mean that the Constitution applied differently depending on who you were. That rights were not rights at all, but privileges extended to people with titles and revoked from everyone else. That a black woman driving a Lamborghini deserved to be searched and humiliated, unless she could prove she was important enough to be left alone. So she said nothing about who she was. Instead, she asked for his badge number. Hargrove stared at her. What? Your badge number. I'd like it, please. He recited it with reluctance, each digit clipped and hard. She repeated it back to confirm. Then she asked him to spell his last name. He sneered. Hargrove. Slow enough for you? She didn't react. She filed it the way she filed everything, with precision, without emotion, with the patience of a woman who had spent 9 years on the federal bench, weighing testimony, dissecting evidence, and holding powerful men accountable when they believed they were untouchable. She had judged cases exactly like this one. She had read transcripts full of the same language, the same pretexts, the same arrogance dressed in a uniform. Now she was standing inside one, palms flat against her own car, living every word she had ever read in a case file. Hargrove keyed his radio. I need a K-9 unit at my location, Meridian Boulevard, south of 5th. Judge Okafor Laurent looked at him but said nothing. The temperature that morning was already 87 degrees and climbing. She was standing on asphalt in direct sunlight with no shade and no water. In the backseat of the Lamborghini, her mother's prescription medications sat in the zippered bag Hargrove had torn open, bottles scattered across dark leather that was absorbing every degree of heat the sun could give it. 2 of those prescriptions were temperature sensitive. The labels said so clearly. Hargrove had read those labels. He didn't care. The K-9 unit arrived 28 minutes later. Officer Dean Sutcliffe, 36, stepped out with a Belgian Malinois on a short lead. The dog circled the vehicle once, then again. It showed no alert behavior. No sit, no paw, no change in breathing or posture. Sutcliffe looked at Hargrove. I'm not getting anything. Hargrove shook his head. He paused near the rear quarter. That's a partial alert. Go again. Sutcliffe glanced at Fitch. Fitch looked at the ground. Neither of them believed what Hargrove had just said, and the body camera caught the look between them clearly. Sutcliffe walked the dog around a 3rd time. Nothing. Hargrove ordered the vehicle searched again. Fitch opened the rear hatch and moved things that had already been moved. Sutcliffe stood to the side, leash in hand, silent. Fitch spoke quietly, barely audible on the body camera audio, but recovered during forensic enhancement. "Maybe we should wrap this up." Hargrove didn't turn around. "Shut up and finish." By the time it was over, 57 minutes had passed since the initial stop. 57 minutes for a lane change that was executed legally. 57 minutes that produced no citation, no charge, no arrest, and no apology. Hargrove handed back her documents without a word. Judge Okafor Laurent gathered the medication bottles from the back seat, now warm to the touch. She noticed the scuff on the driver's seat leather where Fitch had leaned his tool belt. She sat down, closed the door, and pulled away from the curb at exactly the speed limit. She did not look back. Hargrove watched the Lamborghini disappear down Meridian Boulevard and returned to his cruiser. He logged the stop as a routine traffic contact with no further action. He had no idea that the woman he had just spent an hour degrading would by morning have the full weight of the federal government bearing down on him with a force his badge had never prepared him for. At 7:15 Monday morning, Judge Geneviève Okafor Laurent sat at her desk in her home office with a legal pad, a pen, and a phone. She did not call the Crestwood Police Department. She did not file a civilian complaint. She did not leave a message with Internal Affairs. She called the United States Department of Justice Civil Rights Division. She identified herself by name and title. She provided her case number from the Fourth Circuit, her judicial appointment reference, and a detailed oral account of the stop, timed to the minute, citing the specific constitutional violations by amendment and clause. She then called the FBI field office and made the same report. Then the Office of Inspector General. Each call was precise, measured, and without emotion. She spoke the way she wrote opinions. Facts first, law second, conclusions last. By 8:30 a.m., she had submitted a written account, 7 pages, single-spaced, with timestamps drawn from her own memory and cross-referenced against the time she had noted on the dashboard clock during the stop. She requested preservation of all footage, Hargrove's dash cam, his body camera, Fitch's body camera, and the K-9 unit's records. She requested Hargrove's personnel file, his stop history, and his civil asset forfeiture records. Then she made one more call. Not to an agency, but to a civil rights litigation firm with a national reputation for police misconduct cases. She told them she was not calling for herself. She was calling because she wanted to know how many other people Brent Hargrove had done this to. People who didn't have a law degree. People who didn't have a title. People who didn't have the ability to make the calls she had just made. By the time Judge Okafor Laurent closed her legal pad, the machinery of federal accountability was already turning, and Officer Brent Hargrove was on his way to work with no idea that his name was now in 3 federal databases. The footage arrived at the DOJ Civil Rights Division by secure transfer on Tuesday. Investigators reviewed every second from 4 separate sources. The dashcam came first. It showed the Lamborghini Urus approaching the intersection of Walnut and 5th, signaling a lane change 3 full seconds before merging and completing the maneuver cleanly within the posted speed limit. The failure to signal that Hargrove had used as his pretext for the stop had never occurred. The body camera footage was worse. It captured Hargrove's tone from the first word, the immediate demand to know whose car it was, the prolonged examination of documents that were in perfect order. Every one of them. Women like you don't. Every one of them. Women like you don't come by cars like this. Did your boyfriend buy it for you? This car costs more than you'd make in 10 years. Audio forensic enhancement recovered something the body camera microphone had barely caught in real time. Early in the stop, before Fitch had arrived, Hargrove had leaned toward his radio and whispered, "Bet you anything this thing's stolen or bought with dirty money. Look at her." The K-9 unit's records collapsed the marijuana claim entirely. Officer Sutcliffe, under questioning, admitted the dog had shown no genuine alert behavior at any point during the search. When asked about the partial alert Hargrove had claimed, Sutcliffe paused for a long time before answering. "There was no alert. I told him that. He said to go again. Investigators then pulled Hargrove's stop records. In the past 18 months, he had conducted 214 traffic stops. 178 of them, over 83%, involved Black or Latino drivers. Civil asset forfeiture filings showed he had seized more than $340,000 in cash and personal property during that same period. Charges were filed in fewer than 6% of those seizures. The rest of the property simply disappeared into the system, and the people it belonged to never saw it again. The investigators looked at the numbers, looked at the footage, and understood they were no longer investigating a single traffic stop. They were looking at a career. They arrived at 9 a.m. on a Wednesday without warning. 2 FBI special agents and 3 DOJ Civil Rights Division investigators walked through the front entrance of the Crestwood Police Department, carrying federal subpoenas and a preservation order for all digital records. They did not ask for a meeting. They served the documents at the front desk and requested immediate access to the Chief of Police. Chief Raymond Beckett, 58, came out of his office expecting a courtesy visit. His expression changed within 30 seconds. The subpoenas demanded Hargrove's complete personnel file, all 31 complaint records, every internal affairs investigation and its disposition, body camera server access logs going back 3 years, and all internal communications referencing Hargrove's stop activity, forfeiture records, or civilian complaints. Beckett's first instinct was to push back. He began asking about jurisdiction, about process, about whether the department's legal counsel should be present. The lead FBI agent let him finish, then told him the victim of the stop was a sitting judge on the United States Court of Appeals for the Fourth Circuit. The color left Beckett's face, but the agent continued before the silence could settle. Her title is not why we're here. We're here because the evidence shows a pattern in practice of civil rights violations by an officer your department has protected for 16 years. That's a federal matter, regardless of who he pulled over last Sunday. Hargrove was on patrol when the call came through ordering him back to the station. He was met in the parking lot by a captain who told him to hand over his badge, his firearm, and his cruiser keys. He was escorted inside, placed in an administrative office, and informed he was suspended pending a federal investigation. His face went tight. He asked what this was about. Nobody answered. Fitch was pulled from duty the same morning and placed on administrative leave. The union representative, Victor Spano, arrived within the hour, demanding to know what was happening. An FBI agent took him aside and said one sentence that ended the conversation. Obstruction of a federal civil rights investigation is a felony, Mr. Spano. I suggest you cooperate fully and advise your client to do the same. Spano said nothing further. For the first time in 16 years, the machinery that had shielded Brent Hargrove went completely silent. 3 weeks later, the United States Attorney's Office for the District filed a federal indictment against Officer Brent Hargrove. The charges were severe. Deprivation of rights under color of law, 18 U.S.C. Section 242, conspiracy to commit civil rights violations, filing false police reports, illegal search and seizure in violation of the Fourth Amendment. The indictment ran 34 pages. It did not focus solely on the stop of Judge Genevieve Okafor-Laurent. It detailed a pattern spanning years. 47 identified victims, predominantly Black and Latino, subjected to unlawful stops, fabricated pretexts, warrantless searches, and civil asset forfeitures carried out without probable cause. It described a system in which complaints were filed and buried. Supervisors looked the other way, and one officer operated with impunity because no one above him had the will to stop him. Officer Nolan Fitch was offered cooperation terms within days of the indictment. He accepted. In his testimony to federal investigators, Fitch described what Hargrove was like between stops, the language he used in the cruiser when the body cameras were off, the casual way he selected targets based on race and vehicle type, the comments about certain neighborhoods and certain people that had become so routine, Fitch stopped registering them as unusual. He described an unwritten culture within the department where aggressive stop numbers were rewarded, where complaints from minority residents were treated as the cost of doing business, and where officers who raised concerns were quietly reassigned or frozen out of advancement. Fitch's testimony led investigators to two supervisors, Sergeant Dale Womack and Lieutenant Ira Fontaine, both of whom were named in the indictment as unindicted co-conspirators. Internal emails showed Womack had received at least 9 forwarded complaints about Hargrove over 4 years and had closed every one without action. Fontaine had signed off on Hargrove's forfeiture paperwork dozens of times, without once questioning the absence of corresponding charges. Neither man had been careless. They had been deliberate, and the federal government intended to prove it. The trial began on a Tuesday in a federal courtroom 40 miles from Crestwood. Hargrove's defense attorney opened with a simple argument. His client was a veteran officer who followed his training, trusted his instincts, and made judgment calls the way officers did every day. He called it experience. He asked the jury to consider the pressures of the job. The prosecution responded by pressing play. The body camera footage from the Lamborghini stop ran first. The jury watched from Hargrove's own perspective as he fabricated a marijuana claim, emptied a purse across the hood, scattered prescription medication across a back seat, and told a woman standing against her own car that people like her didn't come by vehicles like this. Then prosecutors played footage from 6 other stops, different days, different drivers. The language was nearly identical. The tactics were the same. Each stop involved a Black or Latino driver. Each produced no charges. 12 of Hargrove's other victims took the stand. A retired canine training supervisor testified that no alert behavior had occurred during the Lamborghini search, and that the partial alert, Hargrove claimed, did not exist in any recognized training program. A use of force expert testified that every element of the search violated the Fourth Amendment. Judge Okafor Laurent took the stand last. She was introduced by name alone. To have a stranger's hands press her. To have a stranger's hands press her against her own vehicle. What it felt like to watch her mother's medication scattered across hot leather by a man who never once considered she might be telling the truth. She described the moment Hargrove told her the car cost more than she'd make in 10 years. And she paused, not for effect, because the memory required it. The jury deliberated for less than a day, guilty on every count. The sentencing hearing was held 3 weeks later. Hargrove stood in a dark suit, no badge, no firearm. The presiding judge, the Honorable Catherine Shao, addressed him directly. "Officer Hargrove, you did not merely break the law, you weaponized it. You used the authority entrusted to you to target, humiliate, and rob citizens of their constitutional rights based on the color of their skin. You did this repeatedly, systematically, and without remorse." She sentenced him to 7 years in federal prison, among the harshest sentences for a civil rights violation by a law enforcement officer in the circuit's recent history. He was remanded immediately. Fitch received a suspended sentence for cooperation, but was permanently barred from law enforcement. His silence on Meridian Boulevard had cost him everything his testimony couldn't buy back. The Crestwood Police Department entered a federal consent decree, independent civilian oversight, mandatory demographic data on all stops and forfeitures, published quarterly, comprehensive retraining with annual testing, complete overhaul of internal affairs, including independent review of all racial bias complaints. Sergeant Womack and Lieutenant Fontaine were forced to resign. Chief Beckett announced his retirement 2 days later without public comment. The civil lawsuit was filed on behalf of Judge Okafor Laurent and 38 other identified victims. The city's attorneys reviewed the footage, the stop data, the forfeiture records, the emails, and the federal conviction. Settlement negotiations lasted less than a month. The final amount was $6.4 million, divided among victims according to severity and documentation. The money would matter, but what mattered more was the record. It could not be sealed, it could not be buried, and it could not be undone. Judge Genevieve Okafor-Laurent returned to the bench without ceremony. She did not give interviews. She did not appear on panels about her experience. She let the record speak because the record was comprehensive and the record was permanent. But 6 months after the trial, she accepted an invitation to deliver the keynote address at a national legal conference on constitutional policing. She stood at the podium in the same composure she had carried on Meridian Boulevard and said what she had carried quietly since that Sunday morning. I did not tell that officer who I was, because who I am should not determine whether my rights are respected. The Constitution does not have a VIP lane. The room was silent for a long moment before the applause began. She used a portion of her civil settlement to fund a legal clinic specializing in representation for victims of discriminatory traffic stops, people who had been searched, seized from, humiliated, and sent on their way without charges, without apology, and without anyone to call on Monday morning. The clinic opened in a small office 12 minutes from Meridian Boulevard. Hargrove served his sentence in a federal facility where his former profession made every day harder than the last. He never issued a public apology. He never acknowledged wrongdoing. He maintained until the end that he had been doing his job. After the settlement. Traffic stop racial. After the settlement. Traffic stop racial disparities across the department had dropped by 61%. Complaints of discriminatory enforcement had fallen by more than half. Officers now recorded justification for every stop in writing, and every recording was subject to independent review. In the Oversight Board's office, mounted on the wall behind the conference table, hung a single framed image. It was a still captured from Hargrove's own body camera. It showed Judge Okafor-Laurent standing beside her matte black Lamborghini Urus, palms flat against the paint, chin level, eyes forward. Beneath it, a single line in plain black type. The law applies to everyone, including those who enforce it. If you think this situation was bad, wait until you see what happens in the case on the right-hand side.
I am a federal judge. You can confirm that
Save it.
immediately.
Credentials don't put you above investigation.
I am asking you to verify before escalating this.
You think because you've got a title and a big house in this neighborhood that nobody's gonna...
At 5:47 a.m. on Saturday, March 1st, 2026, 12 armed Homeland Security investigations agents in full tactical gear executed a no-knock raid on a quiet residential home in Silver Spring, Maryland. A flashbang grenade shattered the living room window before the front door had even been touched. Then came the battering ram. The door splintered inward on the first hit. Agents flooded the hallway shouting commands, boots shaking the floor hard enough to knock framed photos off the walls. Barbara Okuosa Adeyemi was pulled from her bed in pajamas and thrown face first onto the hallway floor. Her wrists were zip-tied behind her back before she could finish a sentence. Down the hall, her 16-year-old daughter Rosaline was forced to the ground at gunpoint in her own bedroom. Bodycam footage would later show the girl's face, frozen in terror, a rifle barrel inches from her head. In the next room, 11-year-old Namdi stood paralyzed against his bookshelf, tears streaming down his face, a dark stain spreading down his pajama pants. Barbara's voice cut through the chaos, steady despite the pressure on her spine. "I'm a federal judge. I'm a sitting United States federal judge." The agent kneeling on her back didn't flinch. "Sure you are." Senior Agent Craig Loomis stood in the doorway of the bedroom, arms crossed, watching the scene unfold like a man observing routine work. He said nothing. He didn't need to. He had authorized every second of this. Craig Loomis was 46 years old, with 18 years in federal law enforcement and a career built almost entirely on post-9/11 fear. He had made his name running counterintelligence operations that targeted immigrant communities and black professionals with tenuous or outright fabricated links to foreign governments. 7 of his previous operations had collapsed before reaching trial due to lack of evidence. Not one of those failures resulted in discipline. Two former colleagues had filed internal complaints alleging Loomis manufactured evidence and pressured informants into giving false statements. Both complaints landed on the desk of Supervisory Special Agent Donna Kessler, his section chief. Both were dismissed. Kessler had co-signed nearly every major warrant Loomis had pursued over the past 6 years. Among his peers, Loomis was known for what supervisors politely called big swings, high-profile raids designed to generate press attention and justify budget lines rather than produce convictions. He had been chasing a promotion to Assistant Special Agent in Charge for 2 years. He needed a headline case. And when Barbara Okuwosa Adeyemi's name surfaced during a routine intelligence sweep, Loomis decided she was it. Judge Barbara Okuwosa Adeyemi was born in Baltimore to Nigerian immigrant parents who had come to the United States with nothing but education and discipline. Her father taught biology at a community college. Her mother worked as a hospital administrator. Barbara earned her undergraduate degree from Spelman College, then her law degree from Harvard, where she graduated in the top 5% of her class. She clerked for a federal appellate judge on the Fourth Circuit, then spent 8 years as a prosecutor at the Department of Justice, specializing in national security cases, the very field Craig Loomis now worked in. 4 years ago, she was appointed to the federal bench for the U.S. District Court for the District of Columbia. Senate confirmed. Respected across the legal profession for her fairness, her sharp intellect, and her willingness to check government overreach in surveillance and civil liberties cases. She was one of only a handful of black women serving as federal district judges in the entire country. Her husband, Dr. Chukwuemeka Okuwosa Adeyemi, a cardiologist, had passed away 2 years earlier from pancreatic cancer. Since then, Barbara had been raising Rosaline and Nnamdi alone, balancing a demanding caseload with school pickups, Sunday church, and the quiet grief of a household that still had his reading glasses on the nightstand. She was deeply private, deeply principled, and deeply rooted in her community. She was also, in every measurable way, exactly the kind of person the system was supposed to protect. Instead, the system sent Craig Loomis. 3 months before the raid, Loomis flagged Barbara's name during a broad sweep intelligence review of individuals with what the agency internally labeled connections to nations of concern. Her connection was this. Her late father, a biology professor who had died in 2016, had traveled to Tehran once in 1994 to attend an academic medical conference. That single trip, over 30 years ago, by a dead man, became the seed of the entire case. Loomis built an affidavit alleging that Barbara maintained undisclosed foreign contacts with Iranian intelligence assets. He cited wire transfers she had sent to elderly family members in Lagos as financial activity consistent with covert channels. He pointed to her professional travel to The Hague for a judicial conference, a trip organized by the U.S. State Department, and described it as indicative of clandestine meetings with foreign operatives. Every claim in the affidavit was either a deliberate distortion or an outright fabrication. No corroborating intelligence existed from the CIA, the NNSA, or the FBI. No other agency had flagged her name. No confidential informant had provided testimony. Loomis submitted the warrant application to Magistrate Judge Howard Pruitt, a 61-year-old jurist with a reputation for moving fast through his docket. Pruitt signed the warrant after a 9-minute review. He asked 0 questions. He requested no supporting documentation beyond the affidavit itself. And with that signature, 12 armed agents were authorized to break down the door of a sitting federal judge and drag her from her bed in front of her children. For 3 hours and 14 minutes, agents moved through every room of Barbara Okuwosa Adeyemi's home, with the efficiency of men who believed they were untouchable. Bodycam footage from multiple agents would later document what they seized. Laptops from the home office, cell phones from the kitchen counter and both children's bedrooms, family photo albums pulled from a living room shelf, Barbara's judicial case files, binders and folders containing active federal proceedings, carried out in open boxes without covers or seals, her children's tablets, financial records from a filing cabinet in the hallway, her late husband's medical files, still kept in a drawer beside his side of the bed, and a box of personal letters her father had written to her mother from Nigeria over the course of 40 years. the same letters Loomis had described in his affidavit as coded communications. Barbara sat zip-tied in a kitchen chair the entire time, still in pajamas, watching agents dismantle her home around her. She asked 4 times to call her attorney. Each time she was told the request would be processed later. She asked 3 times for her children to be brought to her, denied without explanation. Down the hall, Rosalind sat in her parents' bedroom with an agent by the door, sobbing, asking over and over if her mother was being arrested. No one answered her. In his own room, Nnamdi sat on the floor with his back against the bed, guarded by an armed agent in tactical gear, clutching a stuffed bear his father had given him. He did not speak. He did not move. Loomis personally entered Barbara's home office and began reading through her judicial case files. When a younger agent standing nearby asked quietly whether they should be handling court documents, Loomis did not hesitate. "She's not a judge today. She's a suspect." 3 minutes after the first flashbang shattered Barbara's living room window, Bill Tavares was standing on his porch across the street in a bathrobe and slippers, phone raised, recording. Tavares was 68 years old, a retired firefighter with 30 years of service and the kind of instinct that told him when something was deeply wrong. He had seen the tactical vehicles pull onto the block at 5:44 a.m. He had watched a dozen agents in helmets and body armor pour out and stack up along the front of the house. And when the grenade went off and the door came down, he pressed record. Over the next 2 hours, his phone captured everything visible from the street. Agents moving in and out carrying boxes, evidence bags clearly containing children's electronics, small tablets and laptops sealed in clear plastic. A moment, 53 minutes into the footage, where an agent walking toward a vehicle held up a framed family photograph and said something to a colleague that made both of them laugh. Tavares caught the moment. Rosalind's face appeared briefly in a second-floor window, tears visible even at distance, before an agent pulled the curtain shut from inside. He walked toward the perimeter once and asked an agent what was happening. He was told to return to his residence immediately. He stepped back, but kept recording. He did not go inside. That evening, sitting in his kitchen with the footage still on his phone, Tavares told a reporter something he would repeat in every interview that followed. "I spent 30 years running into burning buildings. I've seen houses raided for drugs. I've seen bad situations. But I have never in my life seen anything like what they did to that woman and those kids. And I knew right then somebody needed to see this." At 9:15 a.m., 3 hours and 28 minutes after the first agent crossed her threshold, Barbara Okuwosa Adeyemi was finally permitted one phone call. She dialed Obiora Nwankwo, her attorney and one of her closest friends, a constitutional law specialist who had known her since their years together at Harvard. Bodycam footage from the agent standing nearest to the kitchen captured the call. Barbara's voice was controlled, measured, almost clinical, the voice of a woman trained to function under pressure. But the camera also captured what her voice did not betray. Tears running down both cheeks, her jaw tight, her zip-tied hands trembling against the kitchen table. "They broke into my house. They terrorized my children. They are calling me an Iranian spy. I need you here now." Nwankwo arrived in 40 minutes. He walked through the damaged front door in a suit, briefcase in hand, and identified himself immediately as counsel for Judge Okuwosa Adeyemi. Loomis, standing in the living room reviewing a stack of seized documents, barely looked up. Nwankwo stepped closer and spoke clearly enough for every body cam in the room to record it. "My client is a sitting United States federal district judge for the District of Columbia. You have seized active judicial case files from her home office. That is an unconstitutional violation of the separation of powers and judicial independence." The room went quiet. Agent Bryce Dillingham, standing near the hallway, looked at Loomis. 2 agents near the front door exchanged a glance. Loomis's expression did not change, but his hand stopped moving over the papers in front of him. "We'll verify that," he said. Nwankwo's response was immediate. "You should have verified it before you put a flashbang through her window." Loomis stepped into the backyard and called his section chief, Supervisory Special Agent Donna Kessler. He kept his voice low. Kessler ran the name through the Federal Judiciary Personnel Database. The confirmation came back in under 2 minutes. Barbara Okuosa Adeyemi, confirmed sitting judge, United States District Court for the District of Columbia. Appointed by the President of the United States. Senate confirmed. Active caseload of over 60 pending federal cases. The ambient audio from a body cam still recording in the kitchen picked up Kessler's voice through the phone speaker, tight and clipped. "Craig, what have you done?" Loomis said nothing for several seconds. Then he walked back inside and told his team to begin wrapping up. He did not apologize to Barbara. He did not order her zip ties removed immediately. He did not instruct agents to return the judicial case files. Instead, he stepped outside again, pulled out his personal cell phone, and made a second call off Bodycam. No record exists of who he called or what was said. When he returned to the kitchen, he addressed Nwankwo with the flat tone of a man still trying to control a situation that had already left his hands. "The investigation is ongoing. Seized materials will be reviewed and returned if appropriate." Nwankwo was already standing, his briefcase open, a legal pad filled with notes. He looked directly at Loomis, his voice steady and precise. "You have just raided a federal judge's home on fabricated evidence, seized constitutionally protected judicial files, and terrorized her children. This is not going to be reviewed. This is going to be investigated, but not by you." At approximately 10 a.m., more than 4 hours after the raid began, an agent finally cut the zip ties from Barbara Okuosa Adeyemi's wrists. The plastic had left deep red grooves in her skin. She did not rub them. She stood, walked to the hallway, and asked for her children. Nnamdi was brought to her first. The 11-year-old crossed the kitchen at a run and wrapped both arms around her waist so tightly she had to brace herself against the counter. He did not let go for nearly 20 minutes. He did not speak. Rosalind came next, led by an agent she refused to look at. She sat down in a kitchen chair, folded her hands in her lap, and stared at the wall. She said nothing. Her eyes were dry and distant in a way that unsettled Nwankwo more than the tears had. The house looked like it had been torn apart by people who did not care what they broke. Furniture was overturned, drawers had been pulled out and emptied onto floors. Closets stood open with clothes dragged from hangers. Her late husband's study, the room she had kept exactly as he left it, had been ransacked. His books pulled from shelves, his desk drawers dumped. In the upstairs hallway, a framed photograph of her parents' wedding lay face down on the carpet. The glass cracked in a long diagonal line. Barbara walked through every room with Nwankwo beside her, documenting the damage with her phone. She did not cry again. Her voice was flat, precise, cataloging each violation like evidence. "They took the kids' laptops. They took my case files. They took the letters my father wrote to my mother." By 11 a.m., Nwankwo was on the phone with the chief judge of the D.C. District Court. By noon, the Judiciary's administrative office had been formally notified. By 2 p.m., a written complaint had been filed with the Department of Justice, Office of the Inspector General. By evening, 3 United States senators had been quietly briefed by senior judicial officials. The machinery of accountability had begun to move. But inside the house, Nnamdi was still holding on to his mother, and Rosalind had not said a word. On the morning of March 2, 2026, Bill Tavares sent his footage to a reporter at a local television station. He had not slept. By midday, the story was everywhere. Every major outlet ran some version of the same headline, and each one landed harder than the last. Homeland Security raids federal judge's home, calls her Iranian spy. Black federal judge zip-tied in own home during pre-dawn raid. HSI agents seized active judicial case files during raid on judge's home. Legal analysts went on air within hours, calling it one of the most egregious violations of judicial independence in modern American history. Former federal prosecutors described the seizure of active case files as an act that strikes at the foundation of the separation of powers. Civil rights organizations issued formal statements demanding a full federal investigation. The Federal Judges Association, a body that almost never comments publicly on individual cases, released a rare and sharply worded condemnation. Social media erupted. The Bodycam footage had not yet been released, but Tavares's exterior video was viewed over 4 million times by nightfall. One frame in particular spread faster than any other. Agents in tactical gear carrying labeled evidence boxes down the front steps of the house while, in a second-floor window above them, the face of a child was barely visible behind a curtain, mouth open, crying. That image became the defining picture of the case. By late afternoon, HSI leadership moved. Senior Agent Craig Loomis and Supervisory Special Agent Donna Kessler were both placed on administrative leave pending internal review. Magistrate Judge Howard Pruitt, who had signed the warrant after 9 minutes and 0 questions, issued no public comment. But by evening, sources close to the court confirmed he had retained personal legal counsel. The silence from Pruitt's chambers said more than any statement could have. On the afternoon of March 2nd, Obiora Nwankwo filed an emergency motion to unseal and challenge the search warrant affidavit that had authorized the raid on Barbara Okuosa Adeyemi's home. A federal judge in the neighboring District of Maryland granted the motion within hours, citing extraordinary circumstances involving the constitutional integrity of the judiciary. By evening, the affidavit was public, and when legal analysts began reading it on live television, what they found was not an intelligence case. It was a fabrication held together by distortion and audacity. The Iranian connections that Loomis had cited as the foundation of his case amounted to a single trip to Tehran in 1994 by Barbara's late father, a biology professor who had attended an academic medical conference and had been dead for a decade. The covert financial channels were routine wire transfers, fully documented and tax reported, sent to elderly relatives in Lagos. The clandestine meetings at The Hague referred to Barbara's attendance at a judicial conference organized by the United States State Department itself. She had been formally invited by the federal government to attend the very event Loomis described as evidence of espionage. There was no confidential informant named anywhere in the document, no corroborating intelligence from the CIA, the NSA, or the FBI, no interagency coordination of any kind. Loomis had built the entire case from open-source records, deliberate mischaracterizations of lawful activity, and his own unsubstantiated assertions presented as fact. Former federal prosecutors appeared on every major network, calling it the thinnest affidavit they had ever seen approved by a sitting magistrate. Questions mounted quickly about Magistrate Judge Howard Pruitt's 9-minute review, whether he had read the document at all, and whether the rubber stamping of a warrant this baseless represented its own form of institutional failure. By the evening of March 2nd, the legal filings were done, the phone calls to senators had been made, and the news cycle was burning with her name. But inside the house in Silver Spring, none of that reached the 2 children trying to sleep in bedrooms that no longer felt safe. Rosalind had spoken fewer than a dozen words since the morning of the raid. She flinched at sudden sounds, the creak of a door, a car engine outside, the neighbor's dog barking. She asked her mother once, quietly, standing in the hallway before bed, "Are they going to come back?" Barbara told her no, but the question hung in the air because Barbara could not promise that with the certainty her daughter needed. Nnamdi had not slept through the night since March 1st. He had begun wetting the bed again, something he had not done since he was 5 years old. On the night of March 2nd, as Barbara tucked him in, he looked up at her with an expression no 11-year-old should carry and asked, "Did you do something bad, Mama?" Barbara held his face in both hands and told him no. She told him she had done nothing wrong. She told him the people who came to their house had made a mistake. But she could see in his eyes that the answer did not land the way it needed to, because the damage was not about information. It was about what had been taken from him. The belief that his home was a place where nothing could hurt him. After both children were in bed, Barbara closed her bedroom door, sat on the edge of the mattress, and called her sister in Baltimore. Her voice, the same voice that had stayed level through zip ties and interrogation and federal motions, finally broke. "They didn't just raid my house. They stole my children's sense of safety. I don't know how to give it back." A child psychologist who would later evaluate both Rosaline and Namdi would describe their symptoms as consistent with acute trauma disorder. The report would note hypervigilance, sleep disruption, emotional withdrawal, and regressive behavior. It would note that these symptoms had been caused not by an accident or a natural disaster, but by agents of their own government, in their own home, in the dark. As of March 3, 2026, the machinery of accountability is turning, but no one has yet been held to account. Multiple investigations are now open simultaneously, each pulling at a different thread of the same catastrophic failure. The Department of Homeland Security Office of Inspector General has launched a formal probe into Senior Agent Craig Loomis, Agent Bryce Dillingham, Supervisory Special Agent Donna Kessler, and the full approval chain that authorized the warrant. The Department of Justice Inspector General is conducting a separate investigation into whether the raid constituted an obstruction of judicial function, a question with constitutional implications that reach far beyond a single case. The Judicial Conference of the United States, the policymaking body for the entire federal court system, has convened an emergency session focused specifically on the seizure of active case files from a sitting judge's home. In a statement released this morning, the conference called the seizure a direct assault on the independence of the federal judiciary. The FBI has opened a parallel criminal inquiry into whether Loomis fabricated evidence in the affidavit, which, if proven, would constitute a federal crime carrying significant prison time. Congressional leaders from both parties have demanded hearings. Letters have been sent to the DHS Secretary, the Attorney General, and the Director of National Intelligence, requesting full briefings. Loomis, through his attorney, has released a single statement claiming he acted in good faith based on available intelligence. Kessler has not commented publicly. Dillingham has reportedly retained separate counsel and requested to cooperate with investigators. Magistrate Judge Howard Pruitt has been quietly recused from all pending cases on his docket. And the seized judicial files, the active case documents taken from Barbara Okuwosa Adeyemi's home office, have not yet been returned. Among her colleagues on the federal bench, Barbara Okuwosa Adeyemi is described the same way by nearly everyone who knows her work. Principled, thorough, fearless when it matters. Over 4 years on the bench, she built a record that earned respect from prosecutors and defense attorneys alike. But it was her rulings on government surveillance that drew the most attention. She had written multiple opinions pushing back on overreach by federal agencies, including the Department of Homeland Security. She had questioned the scope of warrantless data collection. She had demanded specificity in affidavits where other judges accepted vague language. 2 of her Fourth Amendment opinions had been cited by appellate courts as models of constitutional reasoning. She had, in short, done exactly what a federal judge is supposed to do. She held power accountable. And now, legal commentators across the country are asking the question openly. Was this really an intelligence failure? Or was it retaliation? Was a black woman who dared to check federal authority made into a target by the very apparatus she had held to account? No direct evidence of retaliation has emerged, not yet. But the investigation is ongoing, and the coincidence has not gone unnoticed by anyone paying attention. Barbara herself has not spoken publicly. She has not appeared on camera. She has not given interviews. Through Obira Nwankwo, she released a single written statement on the evening of March 2nd. It read, "I swore an oath to uphold the Constitution of the United States. On March 1st, agents of the federal government broke into my home and violated that Constitution in front of my children. I intend to ensure that every person responsible is held accountable. Not for my sake, but because if they can do this to a federal judge, they can do it to anyone." This story is not finished. As of March 3rd, 2026, no one has been charged. No one has been fired. No one has been arrested. The judicial case files seized from Barbara Okuwosa Adeyemi's home remain in government custody, active federal proceedings handled by agents who had no legal right to touch them. Barbara's children are still not sleeping through the night. Rosaline still flinches when a door closes too hard. Namdi still crawls into his mother's bed before dawn, afraid of the dark in a way he never was before. Craig Loomis is on paid administrative leave, collecting a federal salary from his home, while the woman whose door he broke down tries to explain to an 11-year-old why the people who are supposed to protect them were the ones who came with guns. The investigations are open. The Inspector General is reviewing. The FBI is examining. Congress is demanding answers. But the process is slow, deliberate, and offers no comfort to a family still living in a house with a front door that no longer locks properly, and a living room window still boarded up with plywood where a flashbang grenade came through before sunrise on a Saturday morning. The public is watching. The legal community is watching. Civil rights organizations are watching. And somewhere in a quiet house in Silver Spring, Maryland, a federal judge is sitting on the edge of her daughter's bed, smoothing her hair, telling her it is safe to close her eyes, knowing that she cannot yet prove that is true. This is not a story with a resolution. Not yet. But the cameras were rolling. The Bodycam footage exists. The neighbor's video exists. The affidavit is public. The evidence is preserved. And the people responsible have names, badges, and records that are now under a level of scrutiny they never imagined possible.